JP, thanks again for talking to us at Anchoring Law.
Thank you very much.
We've covered the part about when you were at university and then lecturing at university, both here and abroad.
Yes.
We now move in this segment to your judicial career.
Yes.
When were you appointed as a judge? Well, before you answer that question, let me ask this one. When did it occur to you that Mandla John Hlophe is judicial material?
I think it started when I was at varsity in 1990. I was approached whilst I was teaching law at the University of Transkei to avail myself for a position on the bench. Indeed, in 1990, in October, I was appointed by the then Transkei government as a judge in the Transkei Industrial Court. In fact, during my stint in those 3 years, I wrote 3 judgments, which were subsequently reported there in my CV. So that whilst I was still lecturing, I was approached by Humphrey Lusu, who was a member of the BLA and the chairperson of BLA in Mthatha. And he said to me, look, there are judicial vacancies all over the country. We have confidence in you. Would you like to apply for one of the vacancies? And I applied for a vacancy in this division, which is the Western Cape. I went for an interview in October 1994, and I was appointed as a judge from the 1st of January 1995.
What was the process then? Well, because the JSC hadn't yet been formed, had it?
The JSC was already in place, but it was not as structured as it is today. I was interviewed, I can remember very well. Minister Dala Auma was present at the interview, who was the Minister of Justice at that time. The late Professor Etienne Murenik, he was part of the panel. Chief Justice Ishmael Mahomet, Corbett was also part of the panel, as well as Charles Carlson. I also remember Homoto Moroka, Bulelani Ngoga. So the JSC was already in place in terms of the constitution, but it was not as structured as it is today. Today the JSC is structured. There is a process, for instance, in terms of which complaints are received and objections are received. There is a sifting committee. There are formal interviews which are scheduled. And interestingly, in those days, as I say, it was not as structured as it is. I was interviewed in Free State. That's when the JSC met. I drove all the way from Transkei, Mthatha, all the way to Free State. That's where I was interviewed in October, along with Dennis van Rienen, who was a judge in this division. We were interviewed on the same day and appointed on the same day. He was once senior to me. Of course, when I was appointed DJP, I became senior to him.
No, I remember Dennis van Rienen very well.
Yes.
I pulled a stunt before him on occasion when I was moving an application for the admission of an attorney. I can't remember who it was. I think it was either Mgokri or someone. I can't remember. And I moved the application in isiXhosa.
Yes, which is an official language in this country.
So he was sitting with Justice Traverso at the time. And they didn't expect that. So I moved the application in isiXhosa, and then afterwards I then redid it in English, in what's here called Third Division.
Yes, motion court.
Yes, and magnanimously, Justice van Rienen then called me to chambers and said, listen, that was very impressive, but next time when you do this, can you please give us a forewarning and tell us what to say in response, so that we also appear to be knowledgeable in this isiXhosa language. Unfortunately, there was never an opportunity for me to do that. That was Justice van Rienen. Now, it all started well, JP, your journey towards the judiciary. You came highly recommended. And then you were appointed here in the Western Cape as a judge in, was it 1995?
Yes, with effect from the 1st of January 1995.
Yes,
That's when I took up position as a judge here.
Take us through your experiences while you were an ordinary judge, before you were appointed Deputy Judge President later.
I was the first black person or African to be appointed as a permanent judge in the Superior Court then. Certainly in the Western Cape, I was the first. It was difficult for me. Firstly, the Afrikaans requirement. Afrikaans was heavily used in Cape Town in those days. I remember even the role, if one attended the judges' meeting, on one Friday the language of record would be English, and the following Friday would be Afrikaans. So they were used on a par and in the alternative. A lot of Afrikaans found itself into the records like reviews. So I really struggled, but eventually I was able to find my way. I was still a judge then. But one thing that I would not allow was racism. I started picking this up much earlier in my career. Of course, I was powerless at that time. I was the only judge for quite a while, and I was powerless at that time. Until I became a judge president. I was appointed as a judge president from the 1st of May, year 2000. And I submitted 3 years later after my appointment a report on racism, basically detailing my experience way back from 1995, the things that I observed as a judge and the kind of racism that I observed. I'll give you an example. It is not uncommon that in this division, when as a judge president, by the way, part of the duties of a judge president is to allocate work. I would be approached by white advocates, in particular senior advocates, they would say, we have an urgent application, please allocate a judge to us. If I allocate a black judge, particularly a female black judge, they would suddenly find reasons for saying, no, we are not ready to proceed, the matter is now going to be postponed.
By this time, sorry to interrupt you, by this time there are more black judges in the division.
Yes, there were more.
When you started, you were the only one.
I was the only one in 1995. In 1996, I invited Sandile Ngobo, who later on became Chief Justice. He was also a judge in this division. The number of black judges increased gradually, but certainly when I became judge president, I began to push the transformation agenda without fear and favor. So that in 2004 now, I had already been judge president for 3 years. There was still a number of judges. They were relatively few than what they were, but certainly at that time there were black judges. I think Thandazwa Ndita was appointed around that time. Justice Roshni Ali was appointed in 2001, 2002. Both of them are not white judges. So my experience was this, Mr. Ngalwana. I've just given you an example whereby I'm approached by the practitioners, they want a judge. The moment I give them a black colleague, they would find a reason to avoid appearing before him or her and say, no, this matter, we have now agreed to postpone this matter. How can one postpone the hearing of an urgent matter? Whereas the same colleagues, the same practitioners, if I allocate a matter to a white judge, they go to court without any need for them to engage in settlement or negotiations or postponing the matter. There are other various instances that were tabled. There was also, if you look at my racism report, there was a circular from the head office. Somebody in the head office had issued a circular to judges' secretaries. There were lots of typographical errors. I issued this circular to judges. One judge who is now retired returned it to me. He had scrawled all over this with a red pen, saying to me, look, I can't make sense out of this circular. He was basically telling me that if I knew what I was doing, I should not have circulated this because they were unable to read it. It was so full of typographical errors. There were a number of things that I tabled there. Oh, the other thing, was arbitration. I found that arbitration is robbing the judiciary of our birthright, if I may put it that way, to develop the law. It privatizes litigation. There is huge areas of the law which are dealt with by arbitrators at the expense of our own jurisprudence. I also found that arbitration is heavily used to avoid judges. As we transformed the judiciary, the judges became more and more black in color, and there were more and more females. They would then take the matter out of the judiciary, rush to arbitration, right, in an attempt, clearly, in a desperate attempt to avoid appearing before judges. Right. So there are various instances that I tabled in my racism report.
And this report, sorry to interrupt you, JP, this report was directed at the then Minister of Justice.
I took the report and I gave it to Minister Bridget Mabandla. She was the then Minister of Justice. The other thing, Mr. Ngalwana, that I highlighted in the report was the skewed briefing patterns. Indeed, we still see that even today. Year in and year out, we admit women into the profession. I'm talking about black women. But they don't stay in the profession. Why? Nobody is prepared to take a chance and give them work because they are unknown quantity. Whereas white women who are very well connected in the profession, they would have studied at university with their colleagues, but also those who give work. I'm talking about the industry now, those who control the economy, have more faith in white practitioners than in black practitioners. So if we were to transform the profession in a meaningful way, we would not be losing such a high number of black women. I can tell you what I've done in this division after realizing that black women in particular do not stay in the profession. We started 3 years ago with the many judges, including Pepia and Saldana. What we do, we send circulars to the bar. We invited practitioners who were in the profession for between 0 and 3 years. And we had a series of workshops in this building under my leadership, talking about motion court, how to conduct a trial. We were about 7 judges who participated in that exercise on a voluntary basis. In other words, I realized that it's not enough to wait until someone is recommended to come and act. You want a new person in the profession. You want to make it possible for that person to be nurtured. And if the profession does not nurture practitioners, we are willing as the judiciary to assist in terms of identifying people with the profession, with the potential, and then nurture them.
Okay, can I take you back to the racism report?
Yes.
What did the then Minister of Justice then do with the report, or in relation to the report? Did he, because you made a number of recommendations there.
Yes, I made a number of recommendations. There was not much that was done. I think it's fair to say maybe I was ahead of time. They did not realize the importance and significance of the contents of that report. For instance, as I have said, Mr. Ngalwana, one of the things I raised was skewed briefing patterns. I even argued in the report that lawyers of today are judges of tomorrow. Had I been taken seriously way back in 2004, we would not be saying we don't have enough women to appoint in an acting capacity so that they can be judges tomorrow. There is not much, sadly, that was done at that time other than individuals, including judges and practitioners, whose names were featured in the report. Some of them threatened to sue me, others were preoccupied trying to defend themselves. Meanwhile, I was stating principles and facts, and whatever I said in the racism report is still happening even today, and not much was done. I'm talking about skewed briefing patterns, black practitioners, especially women, not being allowed to take their rightful place in the profession, the bar not doing enough to retain members, right? And the other thing is forum shopping. I raised that in the report. It's not uncommon even today. When they see a black judge, he or she is unknown quantity, they rush to a white colleague.
Yes. Now, I've had this conversation with numerous judges, including the Chief Justice, in an interview such as this regarding briefing patterns and
Yes.
government's role in it. Let me ask you this. It's common knowledge that the largest consumer of legal services in South Africa is government in all
Yes.
its iterations or permutations, whether it's as SOEs or as national departments, municipalities, regional or provincial governments, and so on. Why do you think government doesn't, certainly from where I'm sitting as a practitioner, doesn't appear to be briefing black counsel in droves? I'm not talking about them briefing one set of black practitioners repeatedly, but spreading the work so that one creates a larger pool of black lawyers who can have the ability to ascend to the bench when they are called on to do so. So why isn't government doing this?
I think my answer is going to be twofold. Part of the problem is the state attorney's office. You recall that briefs that counsel like yourself, advocates, get it via the state attorney's office. So the starting point, in my view, is to transform the office of the state attorney so that when we speak in terms of transformation, we are speaking exactly the same language. We are on a par. That, for me, is the first problem. But I think the other problem that the government is not alive to is this. By not briefing black advocates and attorneys, it is backfiring because we're not preparing enough people from which to draw judges, from which to appoint judges. For me, it is a serious problem. We need to believe in ourselves. Perhaps there's a third reason. We perpetuate that which has been perpetuated in the past by our colonizers. Until 1994, as you would know, Mr. Ngalwana, the pursuit of the law has been monopolized by whites. There were very, very few black senior counsel before 1994. To the best of my knowledge, it was the late Louis Square, who subsequently became a judge in the Coastal Court, and perhaps Justice Poswa, and one or two other, of course, Ishmael, but now late. And the result was that we tended, or the government at the time, tended to concentrate a lot more on white practitioners at the expense of black practitioners. There is no excuse for that. What is needed, in my view, is to bring back what I always call the spirit of black consciousness. We must believe in ourselves. And if we do not take ourselves seriously, no one else will. For me, it is wrong for various state departments who want us to believe that transformation is the official policy of the government. But when it's time to deliver, we see a lot of white practitioners at the expense of black practitioners. It's high time that our own government should believe in black practitioners and give them work so that the judges of today, the practitioners of today will get an opportunity and exposure so that at the end of the day they will be good judges tomorrow. So what is needed is a concerted effort which is goal-directed on the part of the government. And perhaps it should be driven by the Minister of Justice to say, look, we have a problem in the department, we need more females, we need more black people, work must be channeled properly through the state attorney's office so that that message filters through all the way from the Minister of Justice to various state attorneys in the country. It must be a deliberate effort, well coordinated and well strategized, and it must be goal-directed. We must say to ourselves, in 10 years' time, for instance, we want to produce maybe 200 black practitioners who are black, who are silk, and we start investing in them now. Must be goal-directed and deliberate.
Thank you, JP. In the next segment, I want us to move to less placid waters, the more controversial issues.
By all means.
So we'll deal with that in the next segment.